Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI #Web Policy Learning. Today, we are gathered here for day one of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, and internship program. This program is organized by the IMPRI, Impact and Policy Research Institute, New Delhi. At the very outset, let me give you a brief background on this certification course. IMPRI, Impact and Policy Research Institute, New Delhi, continuing with its dynamism, is proud to offer its new program, LPPYF, Law and Public Policy Youth Fellowship, starting this summer for 2 months, focusing on the social, legal, and policy issues. The course aims to provide integrated knowledge by connecting both social and legal perspectives. Over 2 months, fellow will get the opportunity to learn about various dimensions of laws and policies, get training for legal tools and their realistic applications to carry out action research fieldwork for 2 weeks project, and prepare a report based on it while interacting with the numerous legal, thematic, and distinguished public policy experts. LPPYF aims to instill the understanding and skills pertaining to law and public policy. The thematic issues covered under this course are the paradigm of international provisions, constitutional laws, sustainable development goals, SDGs, gender justice, environmental crisis and regulations, international human rights, and so on. This online fellowship will have 3 weekly sessions, including a legal, technical, special lecture, and interactive discussion sessions, enabling participants to build capacity in different aspects. Each fellow will be encouraged to perform action research on a thematic area of their choice and write a report on the same by the end of the course. The fellows will also be guided in publishing the blog or article at IMPRI Insights and other renowned journals. This program has an excellent panel of experts who will be sharing their expertise for a 2-month online certificate training course and internship program. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and the expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow, IMPRI. The distinguished experts includes Shri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Wahida Nainar, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Bhartendra Singh Baswan, Dr. Purnima Chauhan, Advocate Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey D. Mello, Dr. Kaustubh K. Bandyopadhyay, Advocate Munalini Deshmukh, Professor Sharmila Guge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Debaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Somyadev Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikendra Singh Panwar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gudavarti, Shri Amit Dubey, Professor Sanghamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita Ayan, Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, energy, and efforts into truly understanding the vital role and complex intricacies of legal and public policy frameworks. The course will enable the participants to comprehend the nuances and technicalities of legal and public policy paradigms and therefore acquire theoretical insights along with technical skills to conduct research. We also have shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your place and pace. Before we start today's session, I would like to announce the housekeeping rules. 1. It is imperative that you join the meeting on time. Second, there will be a Q&A session after each presentation. Third, share your questions in the Q&A box and not in the chat box. Fourth, the questions must not be posted as an anonymous attendee. Fifth, ensure that your questions are precise. Sixth, refrain from making general comments in the question to save time. Our session for day 1 will cover topics of Inaugural Special Address by Shri Sandeep Chachra. Second, Introduction to Law and Public Policy by Professor Vibhuti Patel. To start the session, we invite Professor Vibhuti Patel for our opening chair remarks, followed by Dr. Simi Mehta and Advocate Dr. Shalu Nigam for welcoming you all to the course and to invite Shri Sandeep Chachra ji for Inaugural Special Address. Professor Vibhuti, ma'am, over to you.
Good morning, friends. First of all, I would like to thank IMPRI team, Dr. Arjun Kumar, Dr. Simi Mehta, Dr. Shalu Nigam, and Vidya Jha for putting this course together and putting in a lot of hard work for that. And we welcome Mr. Sandeep Chachra and and the esteemed participants for this course. In introduction, I would like to say that we are continuously faced with challenges of justice, inequity, exclusion, and challenges to progress, economic progress and development. The study of public policy informs the state and the non-state actors as to how it could respond to the new dynamic challenges which are happening in the current 21st century India. As every legislation and government rule requires clear policy formulation, there is a demand for such a course as it enables us to be equipped to design, implement, and evaluate policies and programs and bring desired changes whenever required. We derive inspiration from our transformative Constitution of India while addressing challenges of diverse national needs. This course on an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program provides comprehensive training in understanding, analyzing, and critically reflecting on public policies for complex social problems, translating policies into deliverables program, and evaluating the efficacy of policies. Through this program, IMPRI aims to train young professionals to become policy practitioners capable of supporting inclusive and sustainable development. We emphasize on a dialectical as well as dialogical pedagogy that involves teaching, training, documentation, research, and action that encourages students to question complexities in the practice of public policy arising from real-life situations of people in varied contexts from a diverse set of socio-cultural and economic backgrounds. The program has adopted an innovative pedagogy which combines insightful learning through interactive sessions, short lectures followed by discussions, field exposure, solving the problems for real-world issues, internship, mentoring, and research dissertation. With this, I would like to invite Mr. Sandeep Chachra to give his special remarks.
Ma'am, 1-2 minute remarks by Simi, then
Yeah.
Simi, go on.
Good morning to one and all. Thank you, Shweta, and thank you, Professor Vibhuti Patel, for setting the context to the fellowship program. Understanding the practice-oriented policy and legal research would add much value to the theoretical underpinnings of the nuances of these. And this is where our initiative to bring together the best of intellects, the scholars, and the practitioners converges. So IMPRI, as always, as many of you would know who have been participants to our programs before, it always fosters independent, ethical, and non-partisan research with the aim to co-create ideas and knowledge for the global good. Yeah, so I welcome all the participants and extend my congratulations for your interest and for your decision to join this 2-month intensive fellowship program. I also take the opportunity to thank our lead fellowship advisor, Advocate Dr. Shalu Nigam, Director IMPRI, and the entire IMPRI team for their tireless efforts in making this possible. I also thank all the experts for their time, and I welcome Mr. Sandeep Chachra for his inaugural remarks. So thank you so much, and I wish you all very happy learning and have a great day ahead. I invite Advocate Dr. Shalu Nigam to speak a few words, and then invite Mr. Chachra to for his address. Thank you.
To all of you. I would like to welcome you, welcome all of you to this fellowship. During the course of almost 2 months of exciting journey, we will be sharing a lot of details about law and social policies. And as you already know, that our sessions will be around 50+ sessions, and you have already gone through the list of speakers. So there will be 3 weekly sessions, including a legal hands-on training session, public policy capacity development by practitioners, technical lectures and sessions, and more importantly, the interactive sessions. So where you can ask your questions, you can, we will talk about various other things. Reading and the resource material will be provided, and each week we will share what we have learned and what we have gained from this course. So and we will talk about a lot of questions. Maybe we may not be able to find answers to each and every one of question, but at least a thinking process will start. So with this, I would like to thank the entire IMPRI team and Professor Vibhuti Patel, Dr. Arjun Kumar, Professor Simi Mehta, and Mr. Sandeep Chachra for taking out their valuable time. And with this, I'll go back to Shweta. So please take this session forward, and looking forward, to learn. It's a two-way learning process. So surely all of us will learn together.
Shweta, over to you.
Yes, it is my privilege and honor to introduce the distinguished expert for the inaugural address, Shri Sandeep Chachra ji, Executive Director, Action Aid Association India, and advisor, IMPRI and ex-co-chair, World Urban Campaign, UN Habitat. Welcome, sir, and over to you.
Thank you, Professor Dr. Vibhuti Patel ji. It's always a pleasure to be in a panel with you. Lovely to meet you again, Dr. Simi Mehta. Thank you so much. First time we are meeting Advocate Shalu Nigam. And it's nice to have a warm start to the session. Dr. Arjun Kapoor, it's always this leadership which encourages many, many young people. Of course, our host today, or the moderator today, thank you for introducing me. A very, very warm welcome to all the young people. I believe you have seen many courses, but I believe a lot of young people, those who are in fellowships, those who have shown interest to join this very interesting course, if I may say, on law and public policy. Just now, Dr. Patel was giving interpretation of why this is important. And I think I concur with her on every single word. I think this is a wonderful course to begin with. Let me just say it's a wonderful course because it brings together, I noticed, a wide range of life worlds, if I may use that word. Activists, movement leaders, I noticed a few names, academics, lawyers, practitioners, rooted human rights defenders, but also social organizations. So friends who are joining this course, this is a wonderful opportunity, albeit virtual, but a wonderful opportunity to converse, to discuss, to think together, to synergize at this particular time. Let me also say this over the weekend, and that's a good context setting I want to do. Over the weekend, Action Aid Association, the organization which I have the privilege at this moment of leading, together with Jawaharlal Nehru University and another organization called CARES, we were jointly organizing a convention of coming together of social movements over this last weekend, the one that just went by. And gathered there were rooted social movement leaders, human rights defenders, activists, social and ecological justice defenders, students, importantly, very importantly, students, since the venue was Jawaharlal Nehru University's Convention Center, in a conversation around what challenges people on the ground, the constituencies of those movements are facing, what prospects do they see emerging, and what solidarities could be nurtured. I was there for those 2 days, to those intense, grounded, rooted, emotional conversations, if I may call it, of struggles and efforts of individuals, of constituencies, of people's formations, of small rooted movements in face of tremendous, if I may call it, tremendous headwinds and progressions that they are making. One thing among others which came out very pertinently, friends, is this question of engaging law and public policy from the perspective of what I would call those who are, you would use the word marginalized, oppressed, discriminated, those who would want to see a just and equal India. So their central message, amongst others, was to have a popular interrogation and interpretation in advance of the propositions with reference to both law, how laws are made, what kind of laws are made, what kind of laws need to be made, but also with reference to public policy. And here I'd be remiss, while I know this course will introduce to you the basics of what is laws, what is law, what is public policy, and there are various definitions to the same. But in my introduction and in my opening remarks, I would be remiss if I didn't outline my view of what laws are and what public policy is. Friends, in my opinion, as a practitioner for the last 3 decades in this space of law and public policy, from a rooted ground perspective, public policies are all that arena of where, whether you call it the systems of practices, whether you call it the courses of action, whether you call it laws, whether you call it programs, whether you call it policies per se, whether you call it funding, and the courses of action which public representatives or institutions of government, more properly understood, undertake. Now, these could be them directly, or these could be various associations involved with them. Laws, on the other hand, friends, if I would say, are those in which, in my opinion, derive from the Constitution itself to advance. And that's not just limited to the Constitution, but in one instance from the Constitution to advance the intent of the Constitution in terms of legislations which are justiciable, which at least which are framed in a legal manner. So there's a judicial element involved in it, and therefore can be the recourse can be taken with reference to the legal processes themselves. Laws also derive from the international covenants. Laws also come from the wider sort of perspective or jurisprudence, both on human rights side, but also on other aspects internationally. But I must underline that in addition to these two contexts, laws are also those, path-breaking laws are also those which may not strictly derive from these two spaces, but which have an intent, which progress the society, or sometimes even regress the society out of these spaces. So I would be value neutral in this context, in the definitional context. And therefore, I need to turn into what, in my opinion, friends, without making it too long, I'll make this address somewhat crisper. And if we have space to interact, I could. But it'd be good for me to sort of outline to you what the Lebenswelt or the life world I'm coming from would see as good progressive laws or good laws, and good elements of those laws, and good elements or the substance of public policy. For me, first and foremost, the laws which derive themselves and give life and blood to the intent of our Constitution, that's a good law. That's a good public policy which advances, which gives life and flavor to the intent embodied in the Constitution. And let us remember that our Constitution is not a document in isolation. Our Constitution represents the aspirations, of millions of us, particularly those who discriminated, oppressed under colonial rule, and those long histories of feudalism, coming out of it, frame for ourselves, we the people, the pathway to go ahead on. So any public policy which flowers the intent, the basic tenets, the aspirations embodied in the Constitution, for me is a good law, is a good public policy which advances it. Similarly, any good law or public policy, what I think is a criteria, a good attribute to a progressive law and public policy, is the one which relies itself on fundamental tenets, which are irrefutable, which are, in my opinion, non-debatable, of liberty, of equality, and of freedoms. That's the world that we have imagined and wished for ourselves. That's the world we want to go towards. So when we are talking of public policies, when we are talking of laws, these don't spring up in vacuum. There's a context to it, there's a purpose to it. And this purpose is embodied in those fundamental tenets, which I would point out. Needless to say, friends, there's a third element which I think Dr. Patel in her opening short remarks kind of hinted to, and that to me is an orientation of law and public policy, which is biased, if I may use, or positively biased towards those who've been denied. Our welfare states have an intent, and that intent is to create an equal world, a just world, a world which is just for all. And therefore, those who carry the burdens of history, those who carry the burdens of oppression, those who have been treated unequally, if laws and public policies are in that orientation to seek an equal world, to make a world equal for them, is something that I would call a good law and public policy. Second of all, friends, I also want to say that strong laws, strong public policies are those in our democratic, representative democratic setups, are those in nation states, are those which have legitimacy to them and are therefore legitimately derived. In the democracies, legitimate derivation would mean what? It would mean that there is both substantive legitimacy. What does substantive legitimacy means? Means the substance to that legitimacy. Those policies which are widely consultative, those policies which incorporate ideas and leadership of those who will be affected by those policies positively or negatively, are asked and checked with, those policies which come with ground evidence and knowledge, those policies which come with those skills, are likely to be sound, good policies. Similarly, friends, legitimate laws, legitimate public policies are also those which are procedurally legitimate, not just substantively legitimate. What is procedural legitimacy? Procedural legitimacy is legitimacy which follows the procedures established in the Constitution and in the law. For instance, in our case, the whole system of sort of public consultation, the question of mandate in the lower house of the parliament, passage in the upper house of the parliament, feedback loops, corrections and processes, including sometimes formation of standing committees. I say this because as you go on in the course, you will discover a whole range of issues with reference to procedural legitimacy. Things which should be done, which have not been done, or things which could have been better done. So good public policies and good laws are those which are also procedurally sound and have had a wide range of processual or procedural consultation and processes. That to me is an attribute of a sound public policy, a good public policy, and possibly a good law. Similarly, as I've already mentioned, always a good public policy formulation process, and therefore of laws being a subset of public policy in some regards, are those which base themselves on evidence, which base themselves on data, which base themselves on social knowledge and derivation of social knowledge. which also incorporate the element of what I would call the costs and the benefits. Any law, any public policy would have winners and losers, some who stand to gain, some who stand to lose. So a good benefit analysis, a cost benefit analysis, not just economic cost benefit analysis, it could be an environmental cost benefit analysis, it could be a social cost benefit analysis. Laws and public policies which have incorporated such an analysis, such a policy analysis, are always going to be sound. And before I turn over to a few of the challenges that we face and therefore what needs done, let me also say sound public policy making is one which necessarily involves the implementation bureaucracy of our country, or the implementers, quote unquote, those who are mandated to convert those public policies on the ground. When the tire hits the road, when that rubber hits the road, how to convert it. But having said involvement is important, it is also very important that determining decision making is never given to implementers of laws and policies, because there arises a conflict of interest. If I am implementing a law, then I would see the ease of implementing the law as the only and the first criteria. Of course, that's a simplification, but just to make the point, yes, policy implementers need consulted, need involved, but should not be the ones which are determining and making the laws. And that's why the separation of instruments in our parliamentary democracy, that is why the political executive have the role of framing laws and policies, and not the bureaucracy and the implementers, but these decision makers which are legitimately elected in representational sort of democracy that we have. And this brings me to the challenge of law and public policy making, friends. On two aspects, I'm going to touch on it. I'm sure as you go on the course, you will have much more elaboration. But let me just begin there to hint it out. The first is the question of the form of democracy that we have, and they are interrelated. Friends, representational democracies where we elect people who then make and in a series of processes, in a bi-party system or in a multi-party system, people who then make laws and policies for us are necessarily tend towards what is called democratic majoritarianism. That's the danger of all democracies, and representative democracies in particular. We do not yet have fully authentic participatory democracies. And that presents itself as a danger, particularly in terms of how public policies and laws might be framed from the vantage point of those who are quote unquote numeric minorities, or ethnic minorities, or religious minorities, or sexual minorities. And those examples are enough and more in the long past of our lawmaking, in the long past of our public policy making, and in the recent years of our public policy making. Take, for instance, the example of same-sex marriage. Take, for example, the instance of LGBTQIA+ rights, which is under debate. Take, for example, lawmaking with reference to numeric minorities such as tribals. I think that is a structural challenge that presents itself, in face of public, progressive public welfare-oriented law and public policy making. And in that regard, I want to make the second point. And therefore, in continent countries such as ours, in countries which are ethnically, socially, geographically, ecologically extremely diverse, the issue of how do you embody and how do you flourish consultative, participatory, consensus-based democracies is always a challenge. In this quest, the developments of the 73rd and the 74th Amendment Bill, which take democracy to the grassroots, the Panchayati Raj institutions, the municipalities, the 74th Amendment, and their empowerment with reference to at least plan making, if not full law making, is an important direction, one which needs to see further life and blood, one which needs to see further power and propulsion from all of us. That is the path I would think that the future needs. And before I sort of end, and before I come to an end, let me say that I see few other challenges in addition to the question of the representational nature of democracies that are today evident in the space of public policy making. The first being, of course, I mentioned about the question of representative democracies. The other important being, more recently, this whole rise of the role of religion in public policy making and therefore in terms of law making. There is a tendency, religion was never away, although our state is equidistant from all religions, as I mentioned, all religions are not equally represented in the populations. Therefore, in question of majoritarianism, in the context of rise of religion, it presents a danger, it presents a challenge before public policy making on how do we make public policies where majoritarian elements, ethnic, religious, and so on and so forth, don't come to the fore. Similarly, I also feel that, and it was never away, this whole question of hegemonic economic interests in light of rising inequalities, which Dr. Patel was referring to, the economic concentration of wealth itself, the question of rise of corporations, rise of large businesses, and the role such corporations and businesses have globally and in our own country in influencing public policy and lawmaking to the interests of a few present a huge challenge to all of us. And that, I think, is something we need to be aware of. I'm not going to be listing all challenges, but I still want to mention a third challenge, which is of the question of a re-rise, if I may call it, of the narrative of nativism, of the narrative of chauvinism, of the narrative of identity politics. And therefore, over these years, we have seen attempts, if not always successful, by states, because we are not a unitary system. We are, in a sense, a federal system. A concurrent list is also there with us, where the lawmaking function is divided between the center state and in the common list, the third being the concurrent list, which I'm speaking of. In that context, the rise of identity politics presents yet another challenge. The rise of ethnic or chauvinistic regionalism, nativism presents another challenge. For instance, we've seen in the past years attempts to legislate laws against refugees, those who are not what is called citizens, those who are half citizens, or those who are internal migrants from one state to another. Not always successful, thankfully, but this, of course, alerts us to the danger of the rise, the question of chauvinism and nativism in the arena of policy making. Now, friends, the important point before I end is, yes, this is so. So therefore, what? So therefore, what is in face of us the need for people's policy making? And this is where, friends, the role of social formations, the role of social movements, the role of progressive people's momentums, the role of individual human rights activists, individual human rights defenders, social organizations come in. It's a crying need, and I'll illustrate this role of how it played out in the face of the farm laws, which were recently enacted 2 years ago, and against which a whole range of farmers formations, small peasant formations, middle farmers formations, allied organizations stood tall to in a sense present a challenge for the reversion of those farm laws. We can debate it, but structurally what it displayed was a lawmaking which was not fully legitimate, a lawmaking which was contested, and a lawmaking which was challenged by the farmers of North India and beyond North India as well. So this presents to us a case study in the arena of the challenges and the opportunities with reference to public policies and lawmaking. Similarly, friends, judiciary, therefore, has a very important role. And we've seen that. We have seen in the long history, in the 70 plus years of our nationhood, we have seen judiciary intervene on behest of people, on behest of affected people, to stall, to challenge, and therefore to change many of the laws which might have been construed as against the interests of certain affected peoples themselves. So that to me is the second opportunity and a second check and balance of how lawmaking and the role of people's formations interface with each other. A lot would be said in the coming days and the coming months of your 2-month course on the role of media and lawmaking. I'll not elaborate it, but I do want to say that media has a very, very important role. So it's not only in case of checks and balances. Our recent history, I'll not go way back. Our recent history has many examples in which such formations have progressively intervened to make pro-poor laws and policies. There are numerous examples. I've been associated, my organization has had the privilege of being associated in such formulations in some instances, but there are many, many examples. You could study for yourself the whole process of how the the Forest Rights Act was framed, and how larger formations of forest dwelling people, indigenous people, social organizations, academics, intellectuals, students, analysts, who closely associated themselves with the forest rights struggles led to the formation 2 decades ago, or less than 2 decades ago, into what is called the Forest Rights Act. Similar examples could be given of the Right to Information Act. Similar example could be given of the entire process and procedure, as well as the substance of the formulation of the Right to Education Act, my friends. Similarly, in these last 10-15 years, if I see the emergence or the idea of the law with reference to land acquisition, the Land Acquisition, Rehabilitation and Repatriation Bill, LARR Act itself, of how it was formulated to protect, if not fully, there's cost benefit involved there, but if not fully, the interests of those who get ousted from their habitats and lands, and therefore and the process of rehabilitation, and therefore of resettlement of the people who may have been displaced, quote unquote. This responds to a large need of internally displaced people. I have also personally been associated with the formulation of a public policy on homeless people. Now, these are what I wanted to say, rather than just to give you instances of examples of such progressive laws and policies. What I wanted to tell you is each of these progressions are a direct result of protagonisms of affected communities, of affected constituencies, of progressive thinkers and social organizations themselves. So there's a huge role that people like us, people like you who are attending this course in years to come would have in defending, in advancing, in conceptualizing the kind of just and equal societies that we wish to see, and what therefore needs to be done with reference to public policies and laws in the interests of huge diversities that we have on our continent country. Thank you very much, friends. I wish you all the very best for the next weeks and for the next 2 months in engaging, in discussing, in learning, in giving your own contributions to this very, very important field of public policy and of progressive lawmaking. Thank you, and thank you for this opportunity, the panelists and students. Bye-bye. And if there's time, I'm happy to take a few questions, but if the format doesn't allow it, we can have this discussion some other time.
Thank you so much, sir, for enlightening us. We invite Professor Vibhuti Patel, ma'am, for her remarks on the excellent lecture by Shri Sandeep Chachra.
Thank you, Mr. Sandeep Chachra, for providing a macro perspective on very, very important issues and bringing in the whole discourse on substantive legitimacy and also procedural legitimacy, showing the difference between that, which is so important for us, and also like alerting us about the democratic majoritarianism and the threat of identity politics and the whole sectarian chauvinistic ideologies that are, and it is not so depressing. You are ended with an optimistic note that we the people, if we get united, if we conceptualize rightly, if we defend the rights of people and advance their rights, I think change is possible, transformation is possible in favor of justice and equality and liberty. You also give excellent examples of farmer struggles, forest right bill, and also right to education, right to this information. And I would like to add one more, Mahatma Gandhi National Rural Employment Guarantee Scheme. It was way back in 1972 in response to drought in Maharashtra. The tribal organizations, they demanded employment guarantee scheme, and Maharashtra government started it immediately. And I think now we have an umbrella legislation throughout the country, so which is very important. But to safeguard these provisions is also very important. Fighting for increased allocation, budgetary allocation, both by the union government and the state government is possible. The most important thing that you told about the grassroots democracy and strengthening the local self-government bodies, both urban and rural local self-government bodies, and that these are the important learnings of pandemic also, that they were the ones who were at the forefront. They were not depending on the Zoom calls and Zoom meetings the way the major politicians were doing. They were there with the community, and I think it is very important. The question of displacement, resettlement, extremely important in current context where the mega development projects are playing havoc, environmental standards are lowered. And in this context, I think you have given us a very important way to go ahead for this nearly 55 lectures that we are going to have in this course. Thank you very much. And I think, yeah, the floor is open for question and answer.
If anyone have any question, they can raise their hand. Harsha, you have raised your hand. Do you have any question? Harsha?
Maybe we can have a later interaction, Dr. Arjun, because it's just the beginning, I guess, so people will warm up.
Sure. Harsha, you have raised your hand. Do you want to speak? Okay. Okay. Nonetheless. Right. Thank you. Thank you so much, Chachra sir. Shweta, we can go to the next session, right?
Yes. So Professor Vibhuti Patel is a visiting distinguished professor at IMPRI. Now I would request Professor Vibhuti Patel ji to start a session on the topic of Introduction to Law and Public Policy.
Yeah. Thank you, Shweta. And yeah, I will just share my PPT. It is also I have tried to encompass most of the issues related to this, but is it visible? Yeah.
Yes, yes. No.
Yeah.
You can go full screen now.
It's fine, no?
Perfect. Yeah.
Okay. So I think Mr. Sandeep Chachra has also given us an important framework, and he also said that it is the progressive constitution of India, which is the touchstone of all laws and public policies in our country. And we know that there are, the constitution has encompassed most of the important elements of and the best elements of the world's constitution. But as Baba Sahib Ambedkar said, and even Mr. Chachra also said in his introductory remark, that how to make them implementable and also make them substantive. So the important features of public policy, first of all, are that you have government rules, you have various participatory processes that go on, and the legislative framework, the structures and systems that are created to implement these laws are very important. The historical origins of different laws and public policies, so far as the independent India is concerned, is basically in the parliamentary democracy. So there are two routes. One is a judicial route, which is where the law, recently we have seen so many progressive judgments have been given by the lower courts and session courts and high courts and also Supreme Court of India. And you also have a legislative route where the elected representatives, they play a pivotal role, and they are the ones who introduce either a private member's bill or their party's bill, or a group of elected representatives come together, as we have seen in so many cases like a PCP-NDT Act to curb sex-selective abortion, or we have seen in the law on sati, like or a law GR for that no married woman can be, you can never ask the marital status of a woman when she applies for maternity leave. So maternity and marriage, they are not always connected. So this kind of things happen because of the public participation, global, the discourses that happen in a public domain. Age of consent debate, we know from the 19th century, the kind of debate that is going on about child marriage, and currently the debate when the Child Marriage Act has made the same age of consent for both man and women as 21. It is only the bill, but there is so much of controversy that it has not been translated into an act. And as Mr. Chachra also told us about the farm laws, or even the 4 labor codes, which were introduced during the pandemic, but 12 states have adopted them while the others are opposed to it. The theoretical underpinnings of public policies are very important because it can be regressive public policy also if there are dictators or autocrats who just don't care for the public. So we have seen throughout the 70s and 80s in so many African countries, Latin American countries, even the Asian countries also, we have so many examples where complete curb on people's participation, people's right took place, massive violation of environmental laws took place. People were dislocated in millions and there were no rehabilitation was provided. That is also possible. And at the same time, you have a theoretical underpinnings of justice and equality, people's participation and decent work, where you have legislation which are, or even the government initiatives like Arjun Sen Gupta committee reports, condition of workers in the unorganized sector, the Mammoth report, which is there in public domain, resulted in a law on social protection and social security of Unorganized Workers Act. There is a difference between public policy and law, as Mr. Chachra also told. Law is a subset of public policy. Public policy gives you an overarching framework, where the theoretical foundation, philosophical angle, and the structures and mechanisms, all of them are put in place, and from there the laws can be effective. But both of them are strongly interconnected because without public policy, you can't have the position which the laws will take and the legal safeguards that will be provided. So it is very important to understand this whole thing about the public policy processes. In a dictatorial condition, there would be top-down mechanical vertical policies. Okay, but when there is a democracy where you have people would be taking part in it, they would be based on research and advocacy and documentation, data, evidences, as Mr. Chachra also told us, and there would be evaluation of public policy. What will be the ramifications of Prohibition of Child Marriage Act, or what would be the ramification of environmental standards? What would be the implications on mega development project, about the compensation that should be provided to the people who are oustees? So all these things play a very important role, and all the problems are identified. What kind of safeguards we need to provide when we bring any major change? And then only the public policy implementation can be adopted, like it will be debated in the democratic structures, in the lower and upper houses of parliament, in the state legislative, because whatever may be accepted by the parliament may not be accepted by some states. For example, Panchayati Raj Act, still now Nagaland and Kashmir are not implementing that, because 33% reservation for women, which was adopted in 94, was not acceptable to those states. And they said they would go by the customary law. So it is very important to understand the content of public policy, its issues involved in this, or the objectives of public policy, whether it is for the betterment of society, whether it is to create better infrastructure or a better education system, or what kind of strategies are they followed? Are they top-down approach or a bottom-up approach? Or what are the programs and schemes that are coming up? What kind of budgetary allocation that would be made? What kind of functions and functionaries would be involved? All these things are involved in this public policy. Now, what we see is that public policy subjects and the public policy, like if you have talking about the criminal justice system, Indian Penal Code, about Advocate Dr. Shalu Nigam would tell us more, where you have a policy regarding death penalty, whether you legalize it or not. What are the policies on the drugs? What are the policies on gun control? Currently, major debates are going on in the Western world about the drug control policy. When the public policy is about culture and society, whether they are strongly related, current debate on the abortion, like India has a progressive medical termination of pregnancy act right from 1971. And recently we have amendment in 2017 and 19, again, amendment took place. But there are so many countries which have now reversed back, including US, where abortion, safe abortion on demand by women, they have been abolished. And now so many women have been criminalized for using abortion services. When it comes to the art, what do you call obscene and what do you call decent? What do you call culturally sensitive and what do you call culturally offensive? About that also you have society. We have seen so many cases of painters and artists and filmmakers and writers whose works have been controversial. And in some cultural context, they are accepted. The cartoons made by French cartoonists, France doesn't have a problem, but there were so many other countries where they had a problem. And so it is a very, very sensitive issue. The question of civil rights, that when you can enjoy liberty, equality, freedom of movement, but if the time changes, at the time of pandemic, where all your civil rights were curbed, at the time of war, at the time of natural disaster, at the time of political emergency, the crisis currently Manipur is facing, the curb on civil rights. When it comes to economic affairs, most important thing, budget. Budget is a utilization of public funds, public money, taxpayers' money. So for that also you have a policy, okay? And the budgetary allocation cannot be utilized without mandate of the elected representatives. So the budget of local self-government bodies has to be passed by the elected representatives of corporators and council members. The same way state budget or state government's budget has to be passed by legislators, and the national budget has to be passed by the parliamentarians. The question of taxation, what kind of central taxation, or what would be the share of taxation by the state and center? What would be the jurisdiction of the center when it comes to sales tax, excise duty, GST, income tax? I think they are also very important areas of public policies. The question of education, what should be the national education policy? Education is in India, it is in concurrent list. Okay, so both the state government and the central government have a role to play. The overarching framework is created by the union, by the central government, but then the states, they decide whether to adopt Hindi as a linked language or not. Highly controversial subject. So many southern countries, especially Tamil Nadu, has not accepted it. So education, whether it's elementary education, secondary education, higher education, technical education, IT-based education is also a very important concern in public policy. The question of environment, about which so many example, curry, that I think I need not tell you, your younger generation knows, it's very, very conscious about it, whether it is about the air quality now, or you get the data on air quality on your mobile, on the front, this thing, that what is the level of pollution in Delhi or Bombay, this thing. So what kind of public policy do we have? Like cities like Hyderabad, they have an odd and even numbers of cars. All cars are not allowed on the same day because it creates major traffic jam and air pollution. Global warming is a very important challenge, and the climate crisis is an important challenge. So many states after states are coming up with the policies as well as legislations to mitigate the negative impact and the harmful impact of climate crisis. Government operations about that also. Every legislation, every law, every GR has to be backed by operational guidelines. Without that, the administrators and bureaucrats will not move. So it is very important, whether it's a campaign for financial reform, financial sector reform, or the question of privatization, or the question of support to small and medium scale industries, or the startups. All these things are backed by the policy. The health is a very important area of public policy, and especially after the major pandemic crisis, a lot of attention has been paid to healthcare services, privatization and commercialization of healthcare, strengthening of public health, health insurance, whether it should be health insurance provided by the state and the private parties, the question of Medicare, Nursing Homes Act, the rules about running of corporate hospitals, condition of healthcare workers, all these things are under the jurisdiction of public policy. The question of social welfare, what does it include? Mr. Chachra just mentioned the word welfare. Now, this welfare also includes education, health, skill building, employment, hunger, the question of food security. All these come under the domain of social welfare, about which also we have so many laws as well as public policies. The question of foreign affairs, the diplomacy, the peace building, peacekeeping, question of national security, the defense expenditure, all these are in the domain of public policy. Now, when it comes to the public policy, the question, what has been who are the recipients of these progressive laws? Like if we see the Indian Constitution, it allows the union government and the states and territories of India to set reserve quota. So first important thing we have is a reservation policy, where the particular percentage in education, admission, employment, political bodies, promotion for the socially and educationally backward citizen. This policy is based on the philosophy of equity. The different people are facing different types of intersectional vulnerabilities and marginalities, and for that, you need to provide, as this picture shows, that equality, treating everyone equally, treating everyone equally when they are in an unequal position is not just, okay? So you can see in the first picture, which talks about equality, which gives the same size of the stool to adult person, boy, and child, okay? Which would not happen, which would not be helpful. Because adult person doesn't need stool. He can watch the cricket or the games without stool, because the wall is lower than that of an adult person. While the boy would require a small tool, and the infant would require even the stool with a major, double the height, or it would require 2 stools, okay? So this is very important. So in our country, what we see is that scheduled caste, scheduled tribe, other backward caste, other backward classes. Now we have started even the backward classes, also people from economically weaker section, for them also there has been quota, and for persons with disability, all of them have a quota in some important areas of our country. Now, in 1952, when India was India was the first country to adopt family planning as a state policy, and population policy is a very important mandate in Indian government. It emphasized the family planning to the extent necessary for reducing birth rates and I quote, to stabilize population at the level consistent with requirement of national economy. And in 1976, Government of India announced the first national population policy, and some of the measures to check population growth as a part of this policy include increase the minimum age of legal marriage of age. It was decided in 76, 18 years for girls and 21 years for boys. It was providing monetary incentives for employing birth control. That was also policies of incentives and disincentives were also suggested. The new population policy was announced in 1977 because of the painful experiences of 18 months of emergency rule, where a lot of barbaric practices took place against the poor, unemployed, homeless people. And the main features of the new population policy is included in renaming. Instead of calling it a population policy, it is called family planning programs. So the name is also changed. It is called family welfare program, and which making sterilization voluntary. So the forced sterilization which took place during emergency rule, it became politically also very, very problematic for the ruling party of that time. And all the politicians learned the lesson. And using media for spreading family planning in the rural area. So the communication media, I think Mr. Chachra also said, media has a very important role to play. So even for popularization of public policies and showing the pros and cons and the social cost benefit analysis of public policy, also communication media can play a very important role. But the national population policy in the year 2000, which was the central government's second population policy, it states that immediate objective of the policy is addressing the unmet needs of contraception, health infrastructure, health personnel, and providing integral service delivery for basic reproductive and child health care. I would like to say that more than 20 states in our country currently are below stabilization. That means total fertility rate is less than 2. That means women are producing less than 2 children. Government has identified 300 blocks where TFR is more than 3. That means total for women are producing, an average woman is in a reproductive age is producing more than 3 children, where the intensive healthcare infrastructure has been created for integrated services, health services for basic reproductive and child health care. And it came to planning in India, if we see that the whole history of population policy as it evolved, and I have summarized it, the whole period of planning, right from first 5-year plan to the 12th 5-year plan, we saw the different measures which were used by the government. Initially, first 5-year plan focused on barrier method in condom. Then second 5-year plan talked about the female condom. Third 5-year plan became more and more doctor controlled, and the IUDs, intrauterine devices were introduced. Third and fourth plan. Fifth plan coincided with the emergency period, where the lot of violation of democratic rights of people took place in the name of population control. And sixth 5-year plan, what we see is that more and more focus on women and more hormone-based contraceptives are popularized, and the cafeteria approach in population policy has been promoted in the 6th and 7th and 8th 5-year plan. Even the 9th and 10th and 12th 5-year plan, they also talked about targeted intervention in the areas where TFR was very high. Niti Aayog and Ministry of Health and Family Welfare are also adopting the same stabilization, population stabilization policies. But what we have learned due to from the pandemic also, that reproductive health needs, we should not focus on reproductive health control, but as the ICPD, International Convention on Population and Development, that population is directly connected with the developmental intervention. And what happened during the pandemic, where reproductive health services were not classified as essential services, resulted in massive violation and massive toll on pregnant women, menstruating women, lactating mothers, children's vaccination, polio, and that's why it did not happen only in India, it happened globally. and learnings of this public health response during COVID-19 pandemic for the future disasters is that reproductive health needs of women are extremely important. They are the essential services. And I would like to quote Dr. Natalia Kanem, who says that pregnant women are expected to give birth in coming weeks under difficult conditions. Their ability to access quality care before, during, and after delivery must not be an afterthought. It should be there in the planning stage only, that under any circumstances, reproductive health rights of women cannot be compromised. Now, the health policy, when it comes to the overall health policy of our country, whether it's a public health policy, policy regarding medical relief, professional education, medical research, industrial and occupational health, it is the Alma Mater Declaration of 1978 is the touchstone, which declared that health is a fundamental human right and that the attainment of highest possible level of health is the most important worldwide social goal. India was party to the acceptance of Alma Ata Declaration, and it also set up the board committee, was set up by the government of India in 1943. It also talked about the same thing. The existing gross inequality in health status of people, particularly between developed and developing countries, is a politically, socially, and economically unacceptable. Economic and social development based on new international economic order is a basic importance to the fullest attainment of health for all. Health for all declaration was given by United Nations in 1978, and India also submitted its report subsequently about India's vision of health for all by 2018. Coming to the second very important aspect of public policy is that of a national education policy. It has been debated greatly over the last 3 years. The first national education policy was formulated in the year 1968, which laid the emphasis on compulsory education for children up to the age of 14 years and recommended that 6% of GDP should be allocated for education. It was popularly known as the Kothari Commission's recommendation. Second NEP, National Policy on Education, was introduced in 1986, which gave a special emphasis on removal of disparities and to equalize educational opportunity. And also it emphasized on women's education, education of scheduled caste and scheduled tribe. And also it also talked about more and more spread and expansion of education infrastructure. National policy or National Education Policy 2022 focuses on 5 pillars. One is access, equity, quality, affordability, and accountability. It also talked about the focused on school education. It also talked about the replacing 10+2 system with 5+3+3 +4 system. It also talked about the emphasis on foundational literacy and numeracy. It has accepted multilingualism and the power of language, promotion of regional languages. Examination reforms have taken place drastically. The policy regarding IT-based education, what should be the online, the whole integrated approach of online as well as in-person education. But the main thing is that this educational policy also depends more and more on private-public partnership, that means philanthropic public partnerships, or more and more commercialization of education and privatization of education. National Education Policy talks about the academic bank and also the credit where anyone can enter the education system anytime, anywhere, and anybody can do it. You can take a break for higher education. If you do 1 year of studies, you get certificate. 2 years of studies entitles you to get diploma. 3 years of study entitles you to get bachelor's degree. And if you do it for 4 years, you get honors. So these are some of the flexibilities that it has brought in the education. It also talks about the teaching colleges and teaching universities, and it also talks about the enhancement of research. Universities focusing only on knowledge creation and researches. Now, Coming to third very important policy initiative, and I told even in response to Mr. Chachra's presentation, is the Mahatma Gandhi National Rural Employment Guarantee. It is the Right to Work Amendment, which was passed by the Parliament of India. It talks about the proactively ensuring social inclusion by strengthening livelihood base of rural poor, creation of durable assets. So it is not only Keynesian method of dig the pit and again fill up the pit just to keep people employed. It is not that approach. Our MGNREGA is envisaged for creation of durable assets in the rural areas such as wells, ponds, roads, and canals. Reduction of urban migration from rural areas, that is a very important mandate. Create rural infrastructure by using untapped rural labor. And also the citizens of India can seek MGNREGA. If you are unemployed for a long period, you can apply for MGNREGA. You become eligible for 100 days of paid employment. Anyone who has completed 18 years of age can apply for this scheme. National Rural Livelihood Mission, NRLM, and National Urban Livelihood Mission, they are also very important interventions with the state governments has done as per the new policy adopted by the union government. Reservation for women in the local self-government bodies, as per the 73rd and 74th Constitutional Amendment in 1993, provided for reservation of 1/3 of seats for women in Gram Sabhas, in the village councils, in the Panchayat Samitis, in the district councils, municipal corporations and municipal councils, and also the post of Sarpanch, Chairman and Mayor are also about that. For that also we have a reservation. Constitution 112th Amendment Bill in 2009 provided 50% reservation for women in the urban local self-government bodies and also in the rural self-government bodies. More than 20 states like Andhra Pradesh, Bihar, Chhattisgarh, Jharkhand, Kerala, Maharashtra, Orissa, Rajasthan, Tripura, Uttarakhand, etc. have already adopted the policy of 50% reservation for women in the local self-government bodies, and it has resulted in so many women who have been empowered and who have now entering into the sixth. Some of them are entering into the 4th round or the 5th round or the 6th round of local self-government body elections. When it comes to the national policy for empowerment of women, that was a very important policy which was unanimously passed by the parliamentarians in the year 2001. And it has adopted the life cycle approach from womb to tomb. This policy touches the lives of women. Attempt to revise this policy after 15 years were also made in the year 2016. Several roundtables were taken. They were organized in the country, and still it is still a bill. It has not become a policy. So we are still following the policy which was adopted in 2001, which also mandated each and every ministry to do gender responsive budgeting and also provide enough funds, functions, and functionaries to reduce the gender gap in the 5 crucial areas of education, health, skill building, employment, reduction in gender-based violence, and enhancing decision-making of women in the public bodies. Now, national policy on skill development is an umbrella framework devised by Government of India to develop employable skills among youth for the country through learning and producing workers adequately skilled to meet the requirements of the industry. So the capacity building of skilled trainers on gender mainstreaming is also part of it. Skill India mission, which was transferred which would prepare the Indian youth for Industry 4.0, and now we are also talking Industry 4.0 based on highly automation, artificial intelligence, robotics, and Industry 5.0, which is also informed by machine learning. And also pandemic has also intensified this process. But the challenges that we face when it comes to the Skill India mission is that gender norms come in a way, biases of industrial training institutes and private skill training institutes against imparting skill to women, and the whole mindset, which is also considers technology as with a very phallocentric perspective, that women are not for technology is a male domain, that also comes in the way. And also the question of safety. You are technically equipped, but do you have a safe environment to operate? That also needs to be addressed. Mr. Chachra talked to us about the forest policy, that what were the processes involved, how the people, whether it's tribal people, forest dwellers, urban inhabitants, all of them were involved in bringing more humane, people-oriented forest policy. So the first forest policy, which was adopted by the British colonial government in 1894, which was aimed at custodial and timber-oriented management. There are so many films also now made both by Bollywood and Tollywood, which are a blockbuster film about how draconian methods were used by the colonial masters to criminalize the forest dwellers who had been there for thousands of years, because they wanted timber and they wanted the forest produce, because they had not seen such a huge forest in England. And when they suddenly saw so many deep and very dense forests in India, they wanted to use them for commercial purpose. The post-independence forest policy of 1952 recommended 33% of the area of the country to be brought under forest cover. After a lot of mobilizations by the scheduled caste and by the various tribal and ethnic groups, we got the new law of Environmental Protection Act 1986. Many of you may be knowing the stories of Chipko, where in 1972, women from Tehri Garbal started a massive agitation by hugging the tree against the timber mafia, which was arbitrarily felling the tree and throwing environmental and ecological havoc in that in Himalayas. No, so this was not happening only in Tehri Garbal; it was happening throughout the country. The furniture industry, the timber mafia, the pharma industries who were also sourcing various herbs from the forest areas, they all were cheating and exploiting the tribal people. There were a lot of mobilizations took place, and finally we got this Environmental Protection Act 1986. National Forest Policy 1988 proclaimed to ensure environmental stability and maintenance of ecological balance, including atmospheric equilibrium, which are vital for sustenance of all life forms, means human and non-human animals and plants. They were very important. The important debate that took place around the eucalyptus plantation, bamboo plantation in arid areas, and also they were also very, very helpful. The inputs given, and there are going to be several sessions on environmental law in this course also. A National Forest Policy 1994, which mentioned the establishment of plantations as a key objective towards increasing tree cover and also integrating forest in the context of broader rural development through participatory approach and social forestry approach to expand the tree cover, very important. Forest conservation rules of 2022 have been promulgated solely to implement provisions of Forest Conservation Act 1980. The processes envisaged in the Act and the rules framed thereunder is a parallel process with other statutory processes. During last 2 decades, environmental impact assessment standards have been diluted for mega projects. Massive displacement and relocation of communities have generated protests by the forest dwellers throughout the country. And it is not only in India, but I think most of the Asian countries, even in China, the same thing is happening. National Housing Policy, about which you are going to have a special session. It was adopted in 1987, included an act to establish bank to be known as the National Housing Bank, to operate as principal agency to promote housing finance institutions, both at the local and regional levels, and to provide financial and other support to such institutions and for matters connected therewith and incidentally thereto. The National Housing Policy 1994 recognizes the importance of both rural and urban housing in overall development of rural development and urban poor, and existing central sector housing schemes aimed at benefiting the poor are proposed to be continued, but still we know the major crisis that happened during the pandemic, where more than 3 crore migrant workers had to do reverse migration because they did not have any money left to pay the rent itself, has brought the question of urban housing for the migrant workers is a central issue. Currently, we have only one state, which is Kerala, which has a hostels for the workers in the state, where the state government is managing these hostels and charging a nominal rent. The Slum Areas Improvement and Clearance Act 1956 and the Act number 96 of 1956, which provides for the improvement and clearance of slum areas in certain union territories and for the protection of tenants in such areas from eviction, is highly inadequate. A lot of work has happened by the People's Organization and the Housing Rights Movement to improve this act. The new powers enabled the councils to introduce a scheme in an area with a high proportion of private rented properties in order to tackle issues around poor housing condition, migration and deprivation, and also the crimes which are happening in the urban slums. The demolition drive, the massive displacement of people, disintegration of habitat through coercive method have been challenged by women-led housing movements across the country, and also the housing rights movement and the organizations like ActionAid or the National Campaign for Housing Rights, or the Ghar Bachao Ghar Banao movement in city like Mumbai. Now, coming to the question of fuel, because a lot of work has happened in the question on the area of hazardous fuel, which is used by the poor people and poor women, and the respiratory tract infection that it causes. In this context, the Ujjwala scheme for clean fuel was welcome. But currently what we see that the cylinder, the price of cylinder is so high that these cylinders are just lying the poor people cannot afford. And especially after the pandemic, lot of poverty and scarcity and deprivation has made people again go back to the hazardous fuel, and clean fuel is just not affordable. Women's participation in the energy supply chain as a biomass collectors, producers of charcoal briquettes, dung cakes, improved cook stoves, and the solar light, and also the marketing them in an affordable cost is a major challenge that we are facing, and we need public policy to make energy, the cooking energy for the poor consumers affordable is very, very important challenge that we are facing currently. When it comes to the water policy, water is a very, very contentious issue. India adopted the National Water Policy into 2012, and the document was released. The objective of National Water Policy is to take cognizance of the existing water scarcity, to propose the framework for creation of systems of laws and institutions, and for planning the action for unified national perspective. What we have seen is that gender blind water policies, they are totally insensitive to the woes of women who have to spend more than, on an average, Indian poor woman has to spend nearly 6 years of her life in collection of water in the rural and peri-urban and in the interior parts. So water for industry, water for hotels, water for water parks, water for swimming pools, for the golf grounds, cricket grounds are prioritized over safe drinking water for domestic consumption of the communities. We also see that there is a caste-based segregation of water, availability of water and access to water. Who controls the water resources has been the question asked by Dalit women. Most of the cases of atrocities against Dalit women are directly linked to not having water bodies in the areas where Dalit people who are in the outskirts of the cities, when they try to enter the village to take water, they face atrocities. There have been water disputes between the states, within the community, and within the country. I think about that also. So many negotiations and the changes and the reforms in the water policies take place. Even within the SAARC countries also, so many negotiations have been taking place around the water policies. When it comes to the policies of the gender diversity and gender mainstreaming in the foreign policy, diplomatic architecture. So feminist foreign policy has become a current concern, and also in the Women 20 debate, in the G20 debate also, it has been debated seriously. Gender experts are strongly advocating for feminist foreign policy that would facilitate our international relations by declaration of commitment to women empowerment with group of 8 nations, states which have adopted feminist foreign policy: Sweden, Canada, France, Mexico, Spain, Luxembourg, Germany, Chile. They took the lead. Sweden has gone back again. So feminist foreign policy is an all-inclusive approach which could also push India to foster relations with other nations by engaging with civil society organizations that already have strong human rights standing in those countries. And feminist foreign policy offers India a platform to deepen its commitment to gender equality. The question of policy regarding information technology gained tremendous importance in the 21st century, along with the policy regarding the security, which identifies the rules and procedures for all individuals accessing and using organizations' IT information technology assets and resources, remote access, password creation, password management, portable media, acceptable use. They are the important components of the IT policies aimed to protect information and information infrastructure in cyberspace, build capabilities to prevent and respond to cyber threats, and reduce vulnerabilities and minimize damage from cyber incidents through combination of institutional structures, peoples, processes, technology, and cooperation. Action against stalking, cyber crime, cheating, impersonation, fraud, promotion of pornography, revenge porn, sexual abuse, and threats. We have a very comprehensive information technology rules and the laws. IT Act is very important for the cybersecurity. Gender responsive disaster management policy has become very important, especially in the context of climate crisis, and it's also in the context of health emergency that global communities faced. This is because women and men's differential roles, responsibilities, and access to resources influence how each will be affected by different hazards and how they will cope with and recover from the disasters. Gender and disaster training programs, which have been organized by National Institute of Disaster Management, even IMPRI has organized several such programs. The inclusion of greater number of women in emergency management profession could help in long-term addressing of disaster risk. Experiences of floods, deluge, earthquakes, tsunami, cyclones, famines, and terror attacks, I think, have made it very, very imperative for all of us to be gender responsive. The question of feminist foreign policy, which India has a very, very glorious legacy of person like Dr. Hansa Mehta raising question against Universal Declaration of Man in 1947, where she said that how can you leave 50% of world's population who have faced the major crisis during the 2 world wars, who were the ones who managed their national economy when men were at the front. And because of her intervention in the UN Security Council as a representative of India, that Universal Declaration of Man was seriously examined to include concerns of women and children, and it was renamed as Universal Declaration of Human Rights. She is the one who suggested that man should be replaced by human. And after that, like we have seen the women's throughout the women's movements of 70s, we have seen global solidarity, transnational solidarity happening for gender mainstreaming and bringing gender issues center stage. So right from 1970 to 2020, we have had several approaches. It started with the welfare approach, then we accepted women in development approach. By 90, we talked about gender in development approach. By 2000 year, we talked about the transformative changes that we want to bring. And by 2010, most of the nation states accept intersectional approach. And now we are talking about the social justice approach in the feminist foreign policy. Policies which are informing India's jurisprudence and India's legal framework was most important. This we have a colonial legacy of Indian Penal Code, which was drafted in 1860. We have a Code of Criminal Procedure in 1973, Prevention of Misuse of Section 498A in 1982. And I think that are so like both Dr. Shalu Nigam and Dr. Vahida Nayanar's session is going to go into the great detail of this whole history of legal reforms and the new laws that they have been put in place because of the people's pressure and the public discourses and the judicial intervention. I'm not going into detail, but I have listed all of them. When it comes to the budget policies on the first policies on budget, that means budget which represents the financial plan and the most important policy instrument of the government for establishing macroeconomic stability, fiscal efficiency, strategic priority, and also equitable distribution of resources. So it is a policy-making tool of government to translate government's objectives into programs and services. So you have 4 arms of that. One is a policy formulation and performance analysis, allocating resources efficiently amongst various sectors, industrial sector, agricultural sector, service sector, fishery sector, so very important. Ensuring compliance with the budgetary resources approved by the legislature, and also day-to-day administration of budget, where there has to be transparency, right to information for the people, and no corruption and leakage be allowed. The policy on making the budget gender responsive is very important. India passed the resolution, Indian Parliament adopted gender responsive budgeting in the year 2005. And now and that is why most of the state, nearly 18 state governments have also started making gender budget, a separate listing and separate budgetary statement in the 300% target for women and children, or a gender concerns, 30% targeting of gender concerns within the overall anti-poverty programs. And the third one, so many residual programs that you have in that also can we bring gender mainstreaming. That and Kerala has taken a lead. And this picture that you see is by a young school boy who made this painting, which got the first prize globally. And it is the cover of gender responsive budgeting of Kerala government for the year 2021-22. Sustainable Development Goal as a policy instrument has been accepted. India was also signatory to the Millennium Development Goal, and both the policies objectives are also prepared by the Niti Aayog. We have a involvement of civil societies and the legislators and the elected representatives to see to it that all 17 goals they are implemented, and India is also providing dedicated attention is paid to each and every goal by different ministries and the public institutions, and even the it is a part of corporate social responsibility. So in public policy, in nutshell, what we need a transparency. There is a social accountability, right to information about the funds, functions, functionaries, implementation structures and mechanisms, which is very important. So public policies, they have to be in connection, they have to work in tandem with governance structures, which are administrations, corporate committees. You have to have rules, you have to create various boards. There is to be ethics of public policy, where there is a judicious implementation of public policy. Whatever you have promised has to be implemented, as Mr. Chachra also told us, and it is a question of a social responsibility, your commitment towards the community and to the nation building. Here are some of the references which are there in the public domain. All of these references can be easily downloaded. They are freely available on the internet, and these are written. These documents have been prepared by the researchers, academicians, bureaucrats, parliamentarians of our country, and also by the very important think tanks have also played very important role. UN has also played a very important role in preparation of these documents, which can be treated as a ready reckoner. Thank you very much for the opportunity.
Thank you, ma'am, for such an insightful session. Now the floor is open for questions from the audience.
In the chat,
Yes,
Garvit Gupta has written.
Garvit, you can unmute and ask yourself. Garvit, you can unmute and ask yourself.
Aren't the narratives and discourses that legitimize or produce legitimacy on some level biased or controlled by those whose socioeconomic advantage? You are correct. Hence, at least in today's world, how can we even achieve reliable legitimacy if the access and influence is dictated by the one's socioeconomic status? Moreover, the dominant narrative and discourses may influence the individuals to have desires that may often considered as misaligned with their interest. How do we deal with legitimacy? I think that's why such courses become very important, because as Mr. Chachra also told in his remarks, and my presentation about all different sectoral concerns also show that people's participation becomes very important. There have been very, what you said is good. There's a dominant people who are ruling the roost. But at the same time, we have examples of 18-month-long farmer struggle, which was not only continued by the farmers. It was the civilians like you and me, the students, the urban people, or rural people, people from different states. They also express their solidarity. So I think it's a very important this thing. The state wanted to impose this 3 farm laws, which would enhance commercialized farming, which would benefit only the rich farmers and the corporate world. But it was the people's mandate which prevailed. So I think there have been many such, and I think other examples also about right to information, the way citizens are using right to information to challenge corruption. The whole MG Narega scam, which was unearthed in Mumbai, in Maharashtra state, was mainly because of the initiative taken by the people, by the judicious and honest bureaucrats. It is a difficult struggle, but I think if we individually fight, we may face backlash. But when there is a popular mandate, we create a public opinion, then things change. And I think that is why such courses become very important, because what we do is a demystification of public policy. Public policy, to make public policy, you don't have to be superstar or a superhero or a super politician. Okay? It is people like you and me, if we are well informed, and if we use our critical faculty, and if we show courage of conviction, and we ally with the other people, then we can bring the changes. And this is how the changes happen, even from the most draconian colonial policies to which Gandhiji's the freedom fighters challenge. It was the Dadabhai Naoroji's book, India Today, which unearthed the colonial exploitation and the drain theory he proposed that galvanized people and inspired people like Mahatma Gandhi to fight against colonial rule and the colonial policies. The same way, I think in the post-colonial period also, in the free India, also we have seen similar attempts being made. And that is why we have so many legal reforms as well as people-oriented provisions that we are seeing in our country. So I think change is possible. I feel optimistic. to whom we have to submit report for better improvement in public policy. Yeah. Yeah, I can give you the example that, see, as a citizen, we submit such a report to the politician. We try to make, like when it came to reform in the rape law, what did we do? We submitted our reports to Justice Verma Committee appointed by Prime Minister's office. What did Justice Verma Committee do? They submitted the recommendations to the Parliament of India. They were placed in the Parliament of India, and after that, we saw the changes in the Indian Evidence Act and the major reform in the rape law. Similarly, the question of, sexual harassment at workplace. What happened? It was a public interest litigation filed by organization called Vishakha, which made in the Supreme Court of India, which made Justice Verma Committee, Justice Verma, to come up with the Vishakha guideline. Who made the Vishakha guideline? Women lawyers who were fighting against sexual harassment cases. And these Vishakha guidelines were given by the Supreme Court. So there are two routes. One is the legislative route, other one is the judicial route. So your report can be given to National Human Rights Commission. It can be given to individual parliamentarian who is motivated. It can be given to the Parliament of India. It can be given to different ministries. It can be given to the ministers who are holding the portfolio. It all depends on what is the nature of content in the report. Vivek Jha. Okay.
Okay, then we can move to the next session if we have no more questions. Give some rest to Professor Patel.
Yeah.
No, next. Yeah. Okay. Shweta, let us go ahead.
Thank you, ma'am. For more details of the program, I now invite Advocate Dr. Shalu Nigam to share her expertise and provide a comprehensive overview of the same.
Yeah, I'll just share my screen.
Yes, ma'am, you can go full screen also.
I'll just.
Slideshow. No, slideshow. Just behind that. Yeah.
Problem.
No, not that one. उसके बगल में slide show, right hand side, animation के बगल में, yeah, from beginning.
Yeah, so I'll talk about, how human rights, why we are talking about human rights, why we are talking about laws. So in this session, I'll talk about the genesis of human rights, the role of women in making of Universal Declaration of Human Rights, as Professor Vibhuti Patel has already discussed a bit of that. So maybe we can, talk more about that. I'll talk about International Human Rights Instrument. I'll talk about the Constitution of India, what are fundamental rights and directive principles of state policy, which is there in our Constitution of India, and how these rights have been used in everyday lives by the citizens of India. So we will just look at some of the examples. So if we talk about the genesis of human rights, we have to go into the history of world and history of civilization. We have to look how World War I and II happened, the Holocaust, the colonialism, the racism and mass killings which took place during a particular period of history. And what happened after the Second World War. As per estimates, about 70 to 85 million people have died, and close to 50 million people who survived became refugees, they become displaced, or they become stateless. So starvation, disease, massacre, killings, and bombings, they have all taken a huge toll on lives and resources. The war altered the political and social alignment. And then United Nations was created to establish peace and to foster international collaboration and to prevent future conflicts. So the United Nations, it adopted Universal Declaration of Human Rights as a common standard for all member nations. So this was adopted on 10 December 1948. It was based on French Declaration of Rights of Man and the US Declaration of Independence, but also beside French Declaration and US Declaration, we have around 250 delegates and advisors from 56 countries who participated in making this document. So besides Europe and America, representatives were there from Latin America, Lebanon, China, Egypt, India, Panama, Philippines, Cuba, Soviet Union, and Pakistan, and other countries too participated. So we have all women who played a central role in making of this document. So Eleanor Roosevelt is one of the prominent figure in the drafting committee of the declaration. Then we also have Hansa Mehta and Lakshmi Menon from India, and Begum Shaista Ikramullah from Pakistan. And we have other women like Minerva Bernardino from Dominican Republic, and other women delegates were there from Brazil, France, and Russia, who contributed significantly in making of this draft. So Hansa Mehta, as Professor Patel has already discussed, that she was the first Indian delegate to United Nations Commission on Human Rights for the period between 1947 and 1948. She fought for women's rights in India and abroad. And as she said that, she's known for rephrasing the line, all men are born free and equal to, all human beings are born free and equal, in Article 1 of the Universal Declaration of Human Rights. And she is also the member of Indian Constituent Assembly. Then another delegate was Lakshmi Menon. She was the delegate from India to General Assembly's Third Committee in 1948. She argued for non-discrimination based on sex, as well as she mentioned equal rights for men and women throughout the document. She was the outspoken advocate of universality of human rights and strongly opposed the concept of colonial relativism that sought to deny human rights to the people in the countries under the colonial rule at that point of time. Begum Shaista Ikramullah, she was a delegate to the Third Committee of UN General Assembly on Social, Humanitarian, and Cultural Matters. She was from Pakistan, and she challenged the inclusion, she asked for the inclusion of Article 16 on equal marriage as a way to combat child marriages and forced marriages. She was born in Bengal Presidency in Calcutta in 1915, and later she migrated to Pakistan and then became the Pakistan ambassador to Morocco from 1964 to 1967. So what is this Universal Declaration of Human Rights? Now, this is a document which talks about different rights every person has, as a human being. So it is universal in two aspects. One is, it made jointly where the participants and delegates across the country came together to draft and debate it. Now many people in India say that human rights are, the foreign concept, but no, it is not foreign, because UDHR, we have seen that delegates from different countries have participated. And, it applies to all human beings irrespective of political boundaries. Because all the member states have signed this document, and it holds government accountable to protect the rights of human beings, and all the member states agree to implement it. So these are universal. It cannot be taken away, except in specific situations by due process. These rights are indivisible, and all rights are equal. They are interdependent and interrelated. They are equal and non-discriminatory. So Article 1, for example, it talks about, that all human beings are born free and equal in dignity and rights. Article 2 talks about that, everyone is entitled to all rights and freedoms without distinction of any kind, such as race, color, sex, language, religion, political, or other opinion. Article 3 says that everyone has right to life, liberty, and security. Article 4 is about freedom from slavery. Article 5 is about freedom from torture, and it says that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Article 6 is about right to equal recognition before the law, and that everywhere as a person before the law, a person has right to be recognized. So these are the list of the articles. Article 8 is about access to justice. Article 19 is about freedom from arbitrary detention. Article 10 is about right to a fair trial. Article 12 is about right to privacy. Article 14 is about right to asylum, right to nationality. Then we have Article 16 about right to marriage and family. Article 17 is about right to own property. And this list go up to Article 30. So these are easily available on the internet. You can search for it. The details are also available. So I'll skip this list right now. But Article 29 is also about duty to your community, and Article 30 is about that rights are, they cannot be taken away. So beside this UDHR, we have other instruments, like in 1966, we have International Covenant on Economic, Social and Cultural Rights, which was being made by the United Nations, and again signed by majority of the member parties. Many of the states have signed it, and this covenant protects the right to adequate standard of living, right to education, work, healthcare, and social security. And again, in 1966, there was another covenant which was passed, which is International Covenant on Civil and Political Rights, and it includes right to vote, right to freedom of association, right to fair trial, right to privacy, and right to freedom of religion. Then one of the important convention which was passed in 1979 was Convention on Elimination of Discrimination Against Women, or CEDAW we call it. It says that the state must take steps to eliminate discrimination against women and to ensure that women enjoy human rights in all areas, including education, employment, healthcare, and family life. Then in 1984, we have Convention Against Torture. In 1989, we have Convention on Child Rights. So there the range of conventions, and we have SDGs, Millennium Development Goals, which came in 2000, and then Sustainable Development Goals, as Professor Patel has already mentioned about them. So now India has ratified many of these international treaties, instruments, and conventions. Therefore, human rights are not alien to India. Indian Constitution is, it also talks about the rights. So in part 3, we have fundamental rights, and in part 4, we have directive principles of state policies. The preamble of the Constitution of India, which is very important, and it talks about that India is a sovereign, socialist, secular, democratic, and republic country, and that all its citizens must enjoy justice, liberty, equality, and fraternity. So we generally know that the Constitution is made by the founding fathers, and we all know the names, but we also have 15 women who participated in the making of the Constitution, and I call them as founding mothers. And some of the names are like Amar Swaminathan, Begum Aziza Rasool. You must have heard all those names: Rajkumari, Amrita Kaur, Renu Khare, Sarojini Naidu. So all these 15 women, they participated and made important contribution in the making of the Constitution during the Constituent Assembly debates. They have raised various pertinent issues. So I request you to please read about them. Then coming to the chapters of fundamental rights. Generally, we have 6 fundamental rights, and these are right to equality, right to freedom, right against exploitation, cultural and educational rights, right to freedom of religion, right to constitutional remedies. Now you see that these are basically all civil and political rights. When we talk about social and economic rights, such as right to health, right to education, all those such kinds of rights are mentioned in directive principles of state policy. So what is right to equality? Right to equality is basically Article 14 says that all persons are equal before law. Article 15 says that the state cannot prohibit or discriminate on the grounds of religion, race, caste, sex, or place of birth. Article 16 is about equality of opportunity in the matters of public employment. Article 17 is about abolition of untouchability, and Article 18 is about abolition of titles except in military or academics. So one of the important part is also formal equality and substantive equality, which we need to distinguish, as Professor Patel has also explained, it's about equality and equity, and the state has to ensure that there is no discrimination, and all are treated as equal in an unequal society, in a hierarchical society. We need to protect the rights of those who are at the margins. So Article 15 and 16 permit the state to make special provision for securing the rights of marginalized sections. The purpose is to overcome the discrimination they have suffered for generation. And this is called affirmative discrimination. So in terms of right to freedom, we have Article 19, which talk about freedom of speech and assembly and association, and also right to residence and profession. Article 20 is about protection in respect of offenses. Article 21 is about protection of life and personal liberty. Article 21A, it was added in 2009. The Right to Education Act was made, and it was earlier under Article 45 under Directive Principles of State Policy, and because of the continuous efforts made by the civil society and various organizations and academics and activists to come together. So somebody was asking that where should we go? So these people have worked effortlessly for several years, and then this right to education from DPS, from Directive Principle of State Policy, now is made into right under Article 21A. So now it is a right of a citizen, and you can go to the court and demand that, okay, if you are under from the age of under 14, so you can really demand your right from 6 to 14. Article 22 is about protection against arrest and detention in certain cases. Then we have rights against exploitation. So Article 23 is about prohibition of trafficking in human beings and forced labor. And Article 24 is about prohibition of employment of children in factories and other places. Article 29 is about protection of language, scripts, and cultures of minority communities. And Article 30 says that minorities have right to establish and administer educational institutions. One of the important rights is right to constitutional remedies. If all these rights we have seen till now, if these are being violated, the person has a right to go to the Supreme Court or to the High Court, and the person can say that my rights are being violated. So the courts can grant you remedies. So we have different kinds of writs. So under Article 226, we go to the High Court, and under Article 32, we can go to the Supreme Court. So the different types of writs are habeas corpus, where the court can say, okay, court can tell the state that, okay, release a person from custody if he is being unlawfully detained. So it means that you may have the body. Then another type of writ is writ of mandamus, which says we command, and it secures the performance of public duties by the lower courts, tribunal, or public authorities. Then another writ is that the court can say, okay, we can quash the order already passed by an inferior court, tribunal, or any judicial authority. The writ of prohibition, it's about prohibiting an inferior court from continuing the proceedings in a particular case where it has no jurisdiction to try. And there is a final writ, which is about to restrain a person from holding a public office for which he is not entitled. So coming to the directive principles of state policy, now these are the principles which are fundamental in governance of the country. These are the principles aimed at the establishment of welfare state for the country. They supplement the fundamental rights. They are the guidelines to the government. They established high ideals, but a person cannot directly go to the court and say that my directive principle is being violated. For fundamental rights, you can directly go, but for directive principle of state policy, a person cannot go. But these are the principles which will help the state to make the policies and laws. So directive principles are not binding on the state, but these principles must reflect in all the policies. This is what the Constitution says. So Article 38, we have this right, to promote the the state should promote the welfare of people, by social order through, it should grant justice of all forms, and it should minimize inequalities. Article 39 says that the state shall secure citizens the right to adequate means of livelihood, and there should be no inequalities, equal pay for equal work, and this equal pay for equal work has been translated into law. So right now we have that right to equal pay. There is an act on that. So, and Article 39A talks about promoting equal justice and free legal aid. So we have national legal service authorities being formulated at the national level, and the state legal service authorities which are being created at the state level. They talk. They basically their role is to promote legal awareness and to provide free legal aid to those who are poor. So Article 40 is about village panchayat, and I can go on and on. So basically, I will skip this thing. But basically, Article 42 is about maternity benefits, and this act has already been made, as other previous speakers have spoken about, the policies, and then. Article 44 is about Uniform Civil Code, which is under much discussion. But again, there are various elements to it. There are various perspectives to it. So we will discuss about all these things in the coming 2 months. So now see, for example, Article 47 is about raising the level of nutrition and standard of living and to improve public health. Now, of course, we have this Right to Food Act now, which was made in 2013, but there is a long struggle which we will discuss maybe in the next session. So Article 51 is about the duties of citizens. So the duties of citizens which are given in the Constitution of India is that to abide the Indian Constitution and to respect the ideals. You respect the national flag and national anthem, and uphold and protect the sovereignty, unity, and integrity of the country. And Article 51, which specifically says that all citizens have a duty to promote harmony and to renounce practices which are derogatory to the dignity of women. And also it says about promoting scientific interest. So how these rights are being used in everyday lives, by the citizens. Now, Bhavri Devi case is an important struggle, which took place during the 1992. Bhavri Devi from Pateri, Rajasthan. She was working as Sathin with the Women's Development Program in Rajasthan, and she was gang raped in 1992 by men because she was trying to prevent the child marriage which was taking place in that village. And she was treated badly by the police, and the court acquitted the accused, and it attracted widespread national and international attention. Now, considering the fact that she was employed by the state, and there was, the law didn't come to protect women workers, so women activists and lawyers, they filed a public interest litigation in the Supreme Court, which is started as Vishakha versus State of Rajasthan. In 1997, Supreme Court formulated a guideline using this convention or CEDAW, which we talked about earlier, and interpreting Article 14, 15, 19, and 21. And it came out with Vishakha guideline to prevent sexual harassment at workplace. Now, this Vishakha guideline talks about having internal complaint committees, and what the employers can do, what are the duties of employers to protect women from sexual harassment at workplace. So we will talk about in the coming sessions. Then right to food, which is again an important case which took place again during in 2001. 47 tribals and Dalits were starving to death in Rajasthan, and because there was a lot of drought, and the various civil society members, they came together and they raised the slogan "Bhuke Pet Bhare Godam." That means, the Food Corporation of India, there was tons of food grains were stored, and some of which was rotten, but people outside the godown were dying, and therefore people raised the slogan. And then PUCL filed a petition under Article 32 of the Constitution, and it says that food is inherent to life. And under Article 21, we have right to life with dignity, and therefore food is an important component of living a life with a dignity. And they also evoke this provision under Article 39A and 47, and the objective is to eliminate hunger and malnutrition. And the case went on for several years, I think more than 17-18 years, and where the Supreme Court directed all the state to disperse the food grains under various schemes such as Anganwadi program and midday meal schemes, through public distribution system, maternity benefit schemes for women in BPL categories. And after long struggle, after such a long struggle and long fight within the domain of judiciary, finally the National Food Security Act 2013 was enacted to ensure that food security become a legal entitlement of citizens. And all this the process which they come to this right to food is using the right-based approach. Similarly, if we talk about NOTA, now in election, we see that there is a option called NOTA. Now it came into this place because, again, People's Union for Civil Liberties, they filed a case before the Supreme Court. The case went on for years. And so then the court says that there should be this option of NOTA in that election thing. So now NOTA enables the voter to show that they are not accepting any of the fielded candidates. So this was first used in 2013 in assembly elections held in Chhattisgarh, Mizoram, Rajasthan, and Madhya Pradesh. And petitioner contended that the right to vote is a legal right of the voter, and it also involves freedom of expression. So the court says that in a democratic country, if NOTA option is not provided to the voter, this will force the political parties they should work hard to see that the better candidate should be fielded. Similarly, the right to health has been expanded by the courts through various decisions. We have this Oxfam report in 2020, which says that India is ranked at 129th position in terms of budget and infrastructures, and India spent in 2017 only 3.4% of its annual budget on health. But the Supreme Court over the years, they have elaborated this right. So in Bandhu Mukti Morcha, the Supreme Court says that right to health is a part of right to life under Article 21 of the Constitution, and it is the duty of the state to raise the level of health and nutrition of the citizens of the country. In another case, the court says that it's a public health is a state's primary duty. In Vincent versus Union of India, it says that India is a welfare state, and it is the duty of the state to see that the conditions are congenial to good health. And in 1989, in Permanent Kataria versus Union of India, the Supreme Court ruled that every doctor at government hospital has the professional obligation to extend his service to protect the health of any patient who are approaching them. So after this consistent, efforts by the civil society, by the academicians, by the individuals, in September 29, the 15th Finance Commission, it recommended to declare right to health as a fundamental right. Now it is still not being declared, but the struggle is still going on. If we talk about the rights of female workers in a case it happened earlier, in 1996, the female workers who were on the muster roll, they demanded maternity leave as regular employees, but these were denied to them by the state, and the Municipal Corporation of Delhi, they employed these female workers. In the court, the Municipal Corporation of Delhi pleaded that the maternity benefit can be only given to female workers who are regular employees, but not to employees, not to workers who are there on master roles, and because they were engaged on daily wages. So on 2nd April 1996, the tribunal allowed the claim of female workers and directed the Municipal Corporation of Delhi to provide benefits to them under the Maternity Benefit Act. Again, the MCD went to Supreme Court, but the Supreme Court, in its decision, it says that, you know, all the workers are equal in the eyes of law, and female workers who are engaged on master role or they are regular employees, they all are entitled to maternity benefits under this law. In Olga Tellez versus Bombay Municipal Corporation, again, it is an important case where the petition was filed by pavement and slum dwellers in Bombay, and which says that, you know, they should be allowed to stay on pavements against the order of eviction during the monsoon months by the Bombay Municipal Corporation. So again, the court expanded the notions under Article 21 of the Constitution, and it include, you know, that people have their right to livelihood. You know, and in Justice K.S. Kutuswamy versus Union of India, the court has expanded the notion of right to privacy. And, you know, it says that is a fundamental right under Article 14, 19, and 21 of the Constitution. Again, in terms of right to workers in Air India versus Nargis Mirza, now, the petitioner challenged the employee service regulation because these regulations says that a female, though they are discriminatory against female air hostesses in terms of the retirement age, promotion avenues, their, you know, conditions of termination and other rules. And the court says that, you know, unconstitutional rules cannot be, you know, cannot be working, and therefore they stuck all those kind of rules. In C.B. Muthama's case, now she was the first woman officer in the Indian Foreign Services, and she found that some of the service rules under the Indian Foreign Services were discriminatory, and she challenged, she filed a writ petition before the court, and she complained that a woman, you know, under those rules, a woman has to give an undertaking that she would resign if she get married. But this is not applicable for the male employees. So she challenged this, you know, this provision, and the court says that, you know, such rules are discriminatory and should be removed. So the women have played, you know, they have made much efforts to see that, you know, this discriminatory rules shouldn't be there. In terms of disability rights, in a case in 2021, the petitioner was affected, you know, by writing because of disability. The person cannot write the exam. So UPSC, they refused to offer any help to that person. But the Supreme Court took the step to advance the disability rights. And, you know, again, in another case, a physically handicapped teacher, a member of OBC community, and this person was being transferred to, you know, some other place, far off place, and then he challenged the decision, and he won this case in the Supreme Court in 2022. And it says that, you know, the court says that marginalization of the disabled, you know, it's a human right issue, and, you know, specific consideration should be made in such cases. Again, in Lakshmi versus Union of India in 2014, an acid attack survivor, she approached the court, and the court issued the guideline for the welfare of acid attack survivors, and it also restricted the countrywide sale of acid. And the judgment also led to an amendment in the criminal law and making acid attack an offense, and it also framed compensation schemes for the survivors. So there are many more such of decisions where citizens have challenged the arbitrary rules and laws using constitutional provisions, as well as international human rights paradigm. And courts in several cases have expanded the law to direct the state to take action, and therefore strengthen the democratic ideals. So with this, I'll just, you know, end this, and we will have more discussion on you know, on these issues in the coming 2 months. And during the interactive sessions, we will have discussions about various questions which are emerging, but also, when experts are coming into, to present, whatever their area of expertise is. So that will also give an insight. And so together we will learn. So with this, I'll just stop here. Over to you, Shweta.
Thank you, ma'am, for such an insightful session. I now invite our chair, Professor Vibhuti Patel, ma'am, for her remarks on the lecture. Sorry, ma'am.
Yeah. Thank you, Shweta. Am I audible? Yeah. Hello. Yeah.
Yes, ma'am.
Today we had a very, very rewarding session, starting with Mr. Sandeep Chachra's perspective, which he gave about the substantive law and how policies are made, the whole processes that he explained, my presentation of the overview of public policy, and finally, a very comprehensive presentation of the legal and the jurisprudence and the whole architecture of legal framework that India has created, starting from UDHR, the discourses on UDHR till the present, the criminal laws, labor laws, civil laws. I think now we have got a very important foundation for this course. And I thank Advocate Shalu Nigam for making the complete presentation on the issue of legal framework, which is prevalent in India and the kind of history of reforms that we have had. Thank you.
Would you like to take a question from Rashiji? Rashiji, would you like to speak?
Rashi Son. With capitalist development as dominant conception of development, with no alternative conception that moves away from such a conception of development, how does public policy aim at structural transformation? I would not accept that there is no alternative suggested to capitalist development. In fact, globally, as well as in India, there are so many experiments made, maybe at a micro level or at a community level, but there have been models based on cooperation, mutual respect, sharing and caring. This kind of models have been suggested in several African countries. The whole concept of Ubuntu, which is against the capitalist greed, or the work which the movements in Latin American countries, where the famous educationist Paulo Freire and Ivan Illich have done, or the people's organizations in India, whether it is in NGOs working in the rural and tribal areas, or experiments such as for, say, people-oriented education, demystification of science, or the living in harmony with nature. This kind of experiments, they are giving us glimpses of alternate way of organization of society. Even some of the Scandinavian countries, they have also said that how can we create an atmosphere which can reduce the harmful impact of climate change, and what kind of structures we create so that capitalist greed is reduced, how to enhance the role of public health, public education, state playing a welfare role. Those kind of movements have also taken place. Globally, capitalism is ruling roost. But at the same time, there have been challenges and there have been alternatives, structures and community lifestyles, which have been suggested, and this at a local level, at a micro level. And I think we can amplify their voices. We can come up with the best practices, document them and show it and make a convincing case of that is also possible. So I think that the world is not completely under the capitalist grip.
Can I just add one line?
Yeah.
It's about, this World Economic Forum, like if you just go back to the history of human rights, you'll see that, World Economic Forum, which was held its first meeting, and simultaneously there are civil society organizations which held World Social Forum. So against their slogan of there is no alternative, TINA, which they call it. The civil society which came up with counter slogan which says another world is possible. The multiple words are possible. So capitalism is one field which is trying to dominate, but there are also counter movements, and we have seen in America and US we have this Occupy movement which took place several years back. So capitalism is being challenged and countered by various civil society groups at the international level, at the local level, at the national level, at micro level. So it's going on. The struggle is going on.
Even the ethnic communities in Amazon and all the movements which are led by the ethnic communities in Australia or New Zealand, they have also challenged and shown that there are different ways of living. Even Ubuntu, the whole Africa's concept of Ubuntu, that you can't go ahead alone. You have to take everyone along, and you have to share and care. Create an economy based on share and care. That has come up in several African nations also.
You have any other question?
Yeah.
With the permission of our chair, we can go for vote of thanks.
Yeah, please go ahead. Yeah.
So as we come to the end of day one, Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, an internship program. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day one session, Shri Sandeep Chachra and Professor Vibhuti Patel and Dr. Shalu Nigam, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you this Wednesday, that is 14th June at 11:30 a.m. for our second day of the certification course by distinguished experts, Advocate Dr. Shalu Nigam and Advocate Dr. Vahida Nayanar. We're grateful if you're watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join to our IMPRI #WebPolicyTalk and #WebPolicyLearning. Wishing you a good day. Thank you.